The Civil Rights Act of 1964 is probably the single most important civil rights statute passed by Congress. Title VII, a lot of people have heard that Title VII, Title VII, Title VII. That's the part of the federal law that prohibits discrimination on the basis of race, color, sex, religion, or national origin. So it applies to all employers of a certain size. And, it is extremely important piece of legislation.
So how did this get twisted into something that presumptively makes everything illegal?
Oh my, it didn't take long. It really didn't. It happened fast. And what's funny is that members of Congress in 1964, they were aware of this possibility, and they bent over backwards to make sure that it wouldn't happen. Everett Dirksen, who was the minority leader in the Senate, wanted to make sure that the statute would say that you have to intentionally discriminate. And yet, only a few years after Title VII passed, the EEOC was telling employers, no, it's not just intentional discrimination, but if you have a job qualification that tends to screen out more persons of one race than another, and you don't have, a rock solid business necessity for this, then that itself is a violation of Title VII. And you sort of knock yourself out and look at the statute's wording. Where does it say that job qualifications cannot have what they call a disparate impact or an adverse impact? And it doesn't say that anywhere. In fact, in many places, it says just the opposite.
And this is the amazing thing about reading the your summary of the legislative history, because it's not like people didn't foresee that this could happen. There was a case in Illinois. Illinois had its own version of its own anti-discrimination law, and basically it was Motorola. They tried to give a test, and the test screened out somebody, and then a black man sued and said this is racist because basically the test screens out black people more than white people. And so the exact situation that would come up later, and what was the reaction to that in Congress?
Oh my! I mean, they went crazy to say, "Oh, that won't apply to Title VII. That won't apply. That won't apply." And the newspapers picked this up. Back in those days, the New York Times was running in the opposite direction, and they had a pundit who was saying, this is outrageous that the Illinois Fair Employment Practices Commission, or rather, just a lowly hearing officer, had held that either, it's interesting because it's entirely possible that in the actual case against Motorola, Myart versus Motorola, that they really were race discriminating, that they had lied and said that he'd flunked the test when actually he passed because he took the test in his lawyer's office later and did fine on it. So we'll never know. And Motorola said, we lost the test, so we can't show it to you.
Yeah. The lawyer's office, I don't know if that's the most, neutral. That's true either.
Conceded. However, there was some evidence that he'd actually passed the test. And the fact that Motorola had lost the test was not, that didn't cover them in glory. But all that aside, the hearing officer then says, well, either he passed the test, or even if he didn't, the test is illegal because more whites pass it than African Americans pass it, and so that's when he starts going down this disparate impact road. And the New York Times says this is terrible, and members of Congress get vote on the floor of Congress and say this wouldn't happen under Title VII. Title VII doesn't have that effect, and yet just a few years later, the EEOC is saying, oh yes, it does, and the Supreme Court, to its everlasting discredit, as far as I'm concerned, in the case of Griggs versus Duke Power Company, which is in the early 70s, they say, we defer to the EEOC. We go with their interpretation because they're so much smarter than we are, at least on these matters, so much more expert. And, it's just stunning. It's absolutely stunning.
Yeah. And it's even more than that. It's not that just Congress went crazy. They put a clause in the bill that just sounds like it was written for the Griggs case, doesn't it? It basically says that
it was written for the Maillard case.
Yeah.
Senator Tower from Texas, who ended up actually opposing Title VII. I mean, he was with the Southern segregationists on this, but he was worried enough about the Maillard case that he puts a clause in that basically says, hey, you can use tests. But even more important, Dirksen puts in something that says discrimination has to be intentional in order to be remedied. And Hubert Humphrey, who's the majority leader at the time, says that's fine. I'm okay with that amendment, but I just want to point out that it's unnecessary because that's already implicit in the notion of discriminating because of race, color, sex, religion, or national origin. I mean, that's what it means to discriminate because of that, rather than because of how well someone did on the exam.
Yeah. Is there, I mean, are there, and so what do people say? What do people who like the disparate impact say about the legislative history? When they acknowledge, legislative history matters, what's the argument against, if there is any argument?
I have never heard anyone who supports disparate impact actually do anything even remotely like a deep dive into the legislative history, or for that matter, into the text of the statute. It's just that, their argument is we have to be able to do this, or else we won't be able to fulfill the ultimate goal of Title VII. So they take what you call a purposivist approach to the statute. They say the purpose of this was to get rid of all the obstacles to African American employment success, and the way to do that is to defer to the EEOC's decision to go after disparate impact.
Yeah. So yeah, people who haven't been to law school or people who aren't lawyers, might not know there's different schools of sort of interpreting text and interpreting Constitution, right? And so some people will say, look at the plain words, and some people will say, look at what was originally intended by the legislators. And I think for a lot of people that sounds like common sense. I mean, what else would you use, right? Besides, if we're under the rule of law. And then the alternative case, it's hard to describe without I find it hard to describe without sort of mocking it. I mean, it's basically, I'm trying to describe it fairly. So in the constitutional sense, they call it the living constitution, right? Which basically norms evolve and things change and the world is not what it was in 1964. So maybe you apply something like that where you say I guess what I've seen them say is that basically, look, and what courts have said is basically the 1964 Civil Rights Act was meant to help Black people, right? And that's what it was concerned with. So therefore, how are you going to sit there and stop us from helping Black people? If we want to tell a company, you have to have some balance or something. But the Congress could have wrote a law that just said help Black people, right? Or do what you think is right. And that's not what they did. They had debates over what helping Black people meant and what the law should be in order to do that. And then that's what was debated in public forum, and that was what was passed and signed by the president. And so what am I missing here? What response is there to that?
I'm with you. The whole thing just sounds crazy. The idea that you should continually go to a more abstract level of what Congress did instead of what they actually said. We should look at at what they sort of in some cosmic sense wanted to accomplish. And what was their purpose? Help Black people. Well, you can take any statute. Take the Patriot Act. The idea is to further national security, and therefore we should be able to interpret that act to do whatever it is that the president or whoever the bureaucrat is in charge of this thinks is good for national security. That would be crazy, just crazy.
Yeah. So yeah, that's amazing. So you have this law. It has, so that's the disparate impact standard of Title VII. Basically, anything you do, and it's not just employment; it's every step of the process, right? It's like promotions, it's whatever, how you assign office space. Potentially anything is covered by the language. And so to sort of make the final connection there, how does that make everything illegal?
Basically, everything that's done through employment with a relationship between an employer and employee they all have a disparate impact on some group. You got to remember that that lots of groups are covered by Title VII. So you can have a disparate impact on men, disparate impact on women. Think of how many religions are out there and how they differ from each other, not just in the doctrine of their religion. For example, Unitarians have very high levels of college degrees, whereas Baptists have lower levels of college degrees. So if you require a college degree for a particular job, then it's going to have a disparate impact on Baptists relative to Unitarians. And this goes on absolutely forever. If you, for example, wanted someone with experience in the donut industry, let's say that you are running a donut shop, a little known fact, that is not something that is equal across all national origin groups. Cambodian Americans have more experience in the donut industry. So you're giving an advantage to Cambodian Americans over other groups. Everything has a disparate impact. You'd just be shocked. If you look into it, you will find that just if it's not everything, it is so close to everything. There's always a group that will be better off or worse off because of whatever the job qualification is. I used to offer $10,000 to be given to the favorite charity of whoever could come up with a job qualification that has actually been used in the world that doesn't have a disparate impact on some group. I thought maybe left-handedness, right-handedness would count. Because I can imagine to operate certain machinery, you need somebody who's either left-handed or right-handed. So I can imagine that being used as a job qualification. But it turns out that since left-handedness is thought to be, a negative quality in some ethnic groups, they train their children out of it at a young age. So that group is disproportionately right-handed. Just try to think of a job qualification that doesn't have a disparate impact on some group. Jockeys are disproportionately Hispanic.
Yeah. Yeah. So, you could imagine you could do a lottery. And I guess that's not a qualification. That's just a lottery. But then even how you recruited people for the lottery would probably have a disparate impact unless you're just taking the census data. That's the only theoretical way not to have a disparate impact.
And yet, there are actually lots of arguments about, advertising for a job on the internet has a disparate impact because certain ethnic groups, certain national origin groups or races may have less access to the internet. So that was taken very seriously.
And so, what this sounds like is basically, it's a law. It makes literally everything illegal. And then which that means is, government doesn't have unlimited resources. And so it's basically, this is the definition of arbitrary government power, right? Everything is illegal. You choose what you like and what you dislike, and then you make the law that way.
Yeah, exactly. That's how it works.
The prototypical case of disparate impact, it's Griggs, and that's, where this doctrine, starts within the courts. And so, cognitive tests do have a disparate impact. But then college degrees also have a disparate impact, right? So it's a strange thing that cognitive tests are pretty much presumptively illegal. Technically, yes, you could show business, but in practicality, it's expensive and hard, and people tend not to want to do it. And then but then the college degree is the same thing. So, is there an explanation in law or legislative history or anything we could point to that could say why IQ tests are presumptively illegal or can be problematic, but not college degrees?
Yeah, it's not just IQ tests because it's any kind of a written test. It's very, very hard to get past the EEOC. The rules make it so that you have to spend, very substantial sums of money and time trying to show them this test is a good test, and it doesn't have a disparate impact. The only explanation that comes to mind is that the EEOC likes colleges and universities. That's a Democratic constituency. A very progressive constituency, because otherwise it is just baffling. Because it is, particularly for Latinos, there's a very substantial disparate impact. There's a disparate impact based on religion that's, again, very strong. And Why do they prefer colleges and universities? They like them. What do you mean by saying, this is very arbitrary?